Namaste. Hope you all are doing well. I am Narendra Sivi, retired higher secondary school teacher. Welcome to my channel Law, Life and Layouts. Today I am going to discuss one of the important part of Bharatiya Nyaya Samhita BNS 2023. It is private defense. It consists of two videos. Now video 1 is discussed. The remaining part of this section will discuss shortly. Don't forget to subscribe, like and share this video. Let us start first with some words about BNS 2023. Indian Penal Code 1860 has been replaced in 2023 to Bharatiya Nyaya Samhita BNS 2023. It consists 20 chapters and 358 sections, aiming to modernize Indian criminal laws to cope with the changing times. Some offences are modified, some punishments are modified, some sections are repealed, some definitions and offences are added, introduced community service as new punishment, electronic courts are considered as evidence. These are the changes in the BNS 2023 compared to old Indian Penal Code IPC 1860. BNS officially commenced on July 1st, 2024. It covers all over India. Then we have to discuss about private defense. Private defense, it is in the chapter 3 general exceptions. It is included. Private defense deals section 34 to section 44. That means it consists of 11 sections. Then what is private defense? Private defense is a right of a person to use illegal acts to protect against his body or property when reasonable apprehension of criminal activity. Private defense is a right of a person to use illegal acts to protect or save his body or property against the offender's attack. When reasonable apprehension, that means reasonable apprehension means a fear of danger of criminal activity. There are some limitations and conditions. These limitations and conditions are discussed in this 11th section 34 to 44. Then suppose example of a private defense. Suppose you are traveling in a bus. A person tried to pickpocket you to your purse. You immediately attack that person to resist him to pickpocketing. This resistance is called resistance you applied is called private defense. And that private defense is the right of a person to use illegal acts to protect against his body or property when reasonable apprehension of criminal activity when reasonable apprehension of criminal activity found. Nothing is an offense which is done in the excess of private defense. Nothing is an offense which is done in the excess of private defense. BNS chapter 3 section 34 to 44 for 11 sections deal with private defense. In old IPC section 96 to 106 deals private defense. there is a Latin maxim, necessity is non habere legem. That means necessity has no law. Then section 34 deals general principle. Nothing is an offence which is done in excess of the right of private defence. That is, nothing in offence to save your body or save your property. Example, when a person A suddenly attack B with a knife, to prevent the danger, B resists and during the scuffle, A gets severely hurt. B exercises his right of private defence, so no offence is liable on B. The next section, section 35, exercise private defence for yourself and body of another person. That means you exercise private defence not only for your body but to save the body of another person. Protect your property as well protect the property of another person, or even if to protect the public property, you have the right to exercise private defence. The property may be movable or immovable. That section 35 dates private defence, exercise private defence for yourself and body of another person. Protect your property as well as protect your other's property of another's property or another person's property. Even if to protect the public property, you have to use the exercise the right of private defence. The property may be movable or immovable. Then clause B of 35 is private defence exercise against the following offence on property. Private defence exercise against following offence on property. That is, they are 1. Theft, 2. Robbery, 3. Criminal trespass or mischief, then and next one, housebreaking in night, then misconception or mistake, and attempt of this all above category. That means theft taking place, you can exercise private defence. Then that private defence continue till offender retreat with the property. The private defence continue till offender retreat with the property. Or you can get access to public authority. That means you can access to police or other public officers, and then you can stop the private defence. Then third one is get back the property. You should stop the private defence. When the property is get back, you should stop the doing of private defence. Then second, robbery. What is robbery? Robbery means a theft with violence. Theft with violence is called robbery or extortion. Private defence continues till as long as death or hurt or wrongful restraint of the body. Private defence, you can exercise private defence and it continues till as long as death or hurt or wrongful restraint of the body, or fear of instant death or hurt of wrongful restraint. When you can use this private defence when there is a fear of instant death or hurt or wrongful restraint. Then third one, criminal trespass or mischief. Criminal trespass or mischief. Another person with a criminal intention trespass your property is criminal trespass. Private defence continues as long as the offender continues commission of trespassing. As long as the offender continues the commission of trespassing in your property, you can exercise private defence. Then housebreaking in night. Housebreaking in night, that means housebreaking at after sunset and to next morning sunrise. That night, the housebreaking in night, you can use exercise private defense, and it continues when housebreaking and continues till the offender quits. You can use exercise private defense till the offender quits, or you can access public authority. Then if you get access public authority and the police come into your house, then you can stop private defense. Misconception or mistake. Misconception or mistake. What is misconception or mistake? For example, misconception or mistake. Example, in your child birthday celebration, it is taking place in your home. You saw a stranger among in your guests. You saw a stranger among in your guests. You think that he is a thief. You apply private defense on him and court hold. You apply private defense and court holding. But really, he is a driver of one of the guests. It is a misconception or mistake. That time also you can apply private defense. Then next one, all these happen: theft, robbery or criminal trespass, housebreaking, misconception, attempt to of above category, you can use private defense. Then next, section 36. Private defense against following persons also be exercised. That means unsound mind person, intoxicated person, minor. They have got some exception in charging criminal offence. But you have to use private defense upon an unsound mind person or intoxicated person or minor. Minor means the child up to 7 to 12 years. You can use the minor. You can use exercise private defense against the minor if the minor attack upon you, or intoxicated person or unsounded mind person. Suppose for an unsounded person run after you with a knife. You should execute private defense support him for protecting your body. Section 37. Section 37. Private defense not exercised against the following person. Private defense not exercised against the following person. And who are they? What are the conditions? When there is no reasonable apprehension, that means fear of danger, you should not use use private defense. When there is no reasonable apprehension, fear of danger, you should not use private defense. Second, you should not exercise private defense against a public officer acting in a good faith in the color of his office. That a police officer, you should not exercise private defense against a police officer, and even if the act is not strictly justified by law. Even his act is not justifiable law, you should not use private defense against him. If you think that it is not justifiable law, you can file a case against him later. Or an authorized person by the public officer. Or you should not exercise public defense for on an authorized person by a public officer. Suppose a magistrate uh, appointed a person to arrest you, but you should not exercise private defense upon him. You have a right to verify the authorization. There is a time to request the public authority. You have to authorize, and then you can verify the authority of the person. Expression: reason to believe the person is public officer. You have to believe that there is some reason to believe that he is a public officer. You should not use private defense against him. Then he is an authorized public officer. You can verify the written order of a public servant and genuineness of authorization. That, for example, a magistrate ordered issue an arrest warrant to arrest warrant against you. Then the police officer coming to arrest you. Then you should ask the police person to show the arrest warrant. Then next proportionality. The extent of private defense is proportional to the attack of the offender. The defense should be exercised to prevent the offender. That means the extent of private defense you applied is only in proportional to the attack by the offender. The defense should be exercised to prevent the offender, not extend the great extent. You should not use private defense. There is a landmark case law of private defense. State of UP versus Ram Swarup, Supreme SC 1570 at 1974. The Supreme Court held that private defense should not exercise to perform revenge against any person. Then second is burden of proof. The burden on the accused to private defense is not as heavy the prosecution. It only needs probable. Self-defense is not used to exercise revenge against somebody. That is important. Self-defense is not used to exercise revenge against somebody. Section 38. When can you cause death? When can you cause death? By using private defense, when can you cause death? You kill the offender. When the circumstance you can kill the offender by using private defense. They are discussed here. 1. Death. 2. Grievous hurt. 3. Rape. 4. Unnatural lust. Next one, kidnapping and wrongful confinement. As that in these circumstances you can use private defense till can you cause death. First one, death. Death is an attack of the offender likely cause to death of yourself. Then you can kill the offender. Then second one, grievous hurt. Yes, the assault making the offender, you have an apprehension that makes a grievous hurt which may cause death. Then you kill the offender. Then next one, rape. Assault with the intention of rape on you or other woman. A person or an offender is assaulting a woman to rape. Then you can use your right of private defense. Then you can kill that person. There is no offense upon you. Then unnatural lust. Attack with the intention of gratifying unnatural lust. An offender attack upon you with the intention of gratifying unnatural lust, then you can use private defense and kill that person. Then kidnapping. Attack with the intention of kidnapping or abducting a person, a boy or girl, you can use this this right of private defense and you can kill upon the offender. Then wrongful confinement. Wrongful confinement. Assault with the intention of wrongful confinement. You can use the you can private defense and kill him. But you don't have sufficient time. If you have sufficient time to access the public authority, then you can first access the public authority. Then acid attack. That is acid attack when an apprehension of the act of throwing acid and producing grievous hurt by the offender to you or another person, you can use private defense and kill him and to rescue other person or rescue your body. There is a case law to Darshan Singh versus State of Punjab and others. Supreme Court 2010. SC observed that when reasonable apprehension that imminent threat of death exercise self-defense caused death. SC observed that when reasonable apprehension that imminent threat of death, you can exercise self-defense to cause death. This extreme measure applies when the threat is grave and immediate. The burden of proof lies on those who exercise private defense. Section 39. When right of private defense extends causing any harm other than death. Next section is when right of private defense extends causing any harm other than death. When you cause other than death, you have to face other than death, then what would be the private defense? What would be the extent of private defense? When the offender execute or you have reasonable apprehension other than offense state in section 30, that means last section, that is death, severe hurt, rape, unnatural lust, kidnapping, wrongful confinement or acid attack, you shall exercise love harm to the offender. That means the offender you use force other than death, then you should not use kill him, but you should exercise less harm to the offender. You can use any other modes of private defense other than cause death. You can use other mode of private defense other than cause of death. They may be hurt, disarmament or restraint, but not cause death to the offender. You can use hurt him or disarmament him or restraint, but not cause death of the offender. Note, the remaining section will be discussed in the next video, BNS series, private defense series 2. For printed notes, for any other printed notes of you shall log in my blog. This video is mainly for law students, but it is useful to the public the students writing public service commissions and the awareness, law awareness to the people. Thanking you.